Ms. Wishnu?
Here.
Mr. Santola? Here. Mr. Fernandez?
Here.
Our planning consultants are also present.
Thank you. You can please call the first and only matter for today.
This is the public hearing for the proposed new housing element and fair share plan and related addendum to the land use plan element of the 2018 master plan being considered for adoption.
Thank you. The purpose of tonight's meeting is to conduct a public hearing on a proposed amendment to Livingston's master plan. This amendment relates to amendments to the town's plan, housing element and fair share plan, and spending plan, establishing a new framework for determining and enforcing municipalities' affordable housing obligations under the New Jersey Supreme Court's Mount Laurel Doctrine and in the state's Fair Housing Act. There will be a presentation of the draft amendment, after which the public will have the opportunity for public comment. When all the comments have been heard, the board shall discuss the amendment, whether the amendments are appropriate, and if the board concludes that no amendments to the draft are needed, vote on the housing element and fair share plan and spending plan will take place. So at this time, I would like to ask our professional planners to introduce themselves and to please go through the proposed amendment.
Good evening. Good evening, Mr. Chairman, members of the Planning Board here in Livingston. My name is Graham Petto, principal with the firm Topology here this evening as your affordable housing planner. And we are happy to share the fourth round housing element and fair share plan, which will be in effect for the township moving forward into the fourth round period of 2025 through 2035. I'm also here this evening with a colleague of mine from our office, Mark Linzer, who helped co-author the report with me, and we will walk through the plan for you this evening. We have a couple of slides that we'd like to get on the screen to kick us off and get started. There we go. So to start things off, Mark will walk through kind of the high-level state compliance process, and then I'll go into the details with respect to Livingston itself. So I'm going to turn it over to Mark to allow him to walk us through with the state compliance.
Thank you, Graham, and good evening to the board. Thank you for making this special meeting. Okay, so we can proceed to the next slide. Wonderful. So as we all know, this is very different than the prior rounds. We are operating under new legislation, and how do we get here ultimately to adopt this plan that you see before you? In terms of items from this year, 2025, on January 27th of this year, the Township Council adopted their present and prospective need obligation numbers consistent with methodology prescribed by the statute and analysis performed by yours truly as your affordable housing consultants, adjusting the number from the advisory numbers provided by the DCA. There was then a challenge period specific to the obligation numbers, for which objection was filed against the township's adjustment of its obligation. This was ultimately settled on April 10th of this year for an obligation of $430 for the prospective need obligation. And based on that number, we have prepared the housing element and fair share plan before you today to satisfy the township's obligation for the fourth round, 2025 by 2035. Following June 30, which is the deadline for adoption and submission to the program of the adopted plan, there is a challenge period from July 1 to August 31st, where interested parties may challenge the plan as adopted based on methodology and criteria upon which the plan may be considered deficient or non-compliant with state statute. Following that challenge period, there's a dispute resolution period through the end of 2025, from September to December. During this period, any arbitration or negotiation will occur to resolve any disputes. And ultimately, come March 15th of next year, 2026, is the deadline for the township to implement any and all mechanisms to effectuate the compliance strategy as stipulated in the plan. So to review and summarize the elements of the master plan and how we get to where we are, there are three items to discuss: adjusting the prospective need obligation based on the vacant land adjustment provided, the housing element and fair share plan contents and structure, as well as additional requirements specified for inclusion in the plan. So what is the prospective need obligation? As defined in state statute, it is the projection of low and moderate housing needs based on development and growth, which is reasonably likely to occur in a region or a municipality. The Township of Livingston must provide enough credits to satisfy their obligation. However, as we have conducted a VLA, there is some math that we need to go through to get to the final adjusted obligation. Yes. Thank you. Through a vacant land adjustment, we have adjusted the obligation consistent with methodology prescribed in the statute. The VLA and the analysis of vacant land that may or may not be suitable to provide for affordable housing at a 20% set aside and specified densities generates a realistic development potential, or RDP, being the sum of potential affordable housing units may be yielded from all vacant, unconstrained, developable land at a minimum presumptive density of 6 dwelling units an acre at that 20% affordable set aside that is assumed. Then we get to what we call the likely to redevelop obligation, which, again, going through the math, is that prospective need obligation subtracted by the realistic development potential, and then that value is divided by 4. We've cited below the specific requirements that stipulate that methodology from the statute, where we identify sufficient parcels likely to redevelop during the current round of obligation to address at least 25% of the prospective need obligation that has been adjusted, and adopt realistic zoning to implement same. Lastly, to get to our final adjusted fourth round obligation, we add the RDP and the likely to redevelop, and that is the number to which the township must address. And to address the obligation, we must provide a reasonable likelihood that the affordable housing in the municipality's housing element and fair share plan will actually be constructed or provided during the 10-year period of certification, based upon a careful analysis of the elements in the municipality's plan, including the financial feasibility of each proposed mechanism and the suitability of the specific sites identified. This can take a variety of forms and compliance mechanisms. As is the case for Livingston, we are applying surplus credits and projects identified from the third round. We are also identifying, you can also include applications that are anticipated to receive site plan approval after June 30, 2025, being that the fourth round of affordable housing compliance runs from July 1 of 2025 through June 30, 2035. We can adopt zoning ordinances and redevelopment plans to provide the affordable housing. The municipality may allocate land or funds to support affordable housing projects, as well as bonus credits that are generated by these compliance strategies and projects, which may be up to 25% of the prospective need obligation. And compared to prior rounds, there are a variety of bonus credits available to the township to avail themselves of, falling into 2 buckets. The first, smaller bucket, generates 1 bonus credit per each unit of affordable housing provided. These include special needs housing, permanent supportive housing, and similar projects. Market to affordable conversions, where an existing market rate unit is bought down, so to speak, and de-restricted as an affordable unit, as well as municipal contributions of land or funds to a 100% affordable development. The larger bucket provides half a bonus credit per each unit of affordable housing provided, including partnerships with nonprofit developers to build such housing, transit-oriented development, which is defined as the crow flies, as a half-mile radius from public rail and bus stops, age-restricted housing, redevelopment of commercial sites for affordable housing, extension of affordability controls that are set to expire during the fourth round, as well as any excess very low or 3-bedroom, excess very low income units or excess 3-bedroom units that are provided through projects. So there are 3 main components, or sections rather, of the housing element and fair share plan. The beginning is an orientation, providing the introduction and legal background to how we got here to the statute that we are responding to, from the original Mount Laurel doctrine to today. Next, there's the housing element, which provides a summary of municipal characteristics that might inform housing needs, such as housing conditions, demographic conditions, and employment data. And lastly, the fair share plan, which is kind of the meat and potatoes of this document, which includes the township's compliance strategies to address its adjusted obligation. Lastly, the program has identified additional requirements through Administrative Directive 14-24 that must be included in the housing element and fair share plan. These make up a significant number of the appendices that are included in this document. This includes all ordinances and resolutions that will be required to implement the plan. These do not need to be adopted. These can include draft versions, and ultimately, these are the documents that will facilitate implementation by that March 15th, 2026 deadline. Further, it includes an affirmative marketing plan, spending plan, and resolutions or ordinances appointing the municipal housing liaison and administrative agent.
Thank you, Mark. Before I get into the strategy compliance, I just want to commend the township on their third round compliance, which resulted in an excessive surplus of credit opportunities to carry forward here into the fourth round. This is one of the unique situations that we have not seen in many other communities, so it is really a benefit to the township and has made the compliance approach that we put together here quite easy to facilitate as we move forward into the fourth round. So as my colleague Mark noted, the township did undertake a vacant land adjustment process. This is an exercise to identify, as he noted, vacant properties without constraints that may yield affordable development given the size of the properties. As such, at 6 dwelling units an acre, each of these sites needs to yield at least 5 dwelling units, because with the 20% set aside, then 1 would result in the affordable housing compliance component. Through this process, we've identified the 8 properties listed here on the screen, and each of these sites would yield at minimum 1 affordable dwelling unit. I do want to note and characterize this importantly, that these sites are not proposed for development. These are, the vacant land adjustment analysis requires the municipality to undertake an exercise to figure out how many units could be built as of right on existing open available land at this point. By going through this exercise, we've identified that 13 affordable units could be constructed on existing vacant unconstrained land within the township. However, the legislation allows for us to accommodate those elsewhere within the community. We do not need to use these sites, and we are not planning to use these sites either. Just want to importantly characterize that for everyone here. So as such, as noted, the total realistic development potential that we've identified goes from 430 down to 13 units, which we have targeted for the RDP. Next, we have just a couple of series of maps that just demonstrate our analytical approach using GIS software, Geographic Information Science software. So here is a map demonstrating the vacant properties that would be eligible for environmental constraint analysis, obviously over that 0.83 acres or a property of at least that size, which would yield 6 dwelling units per acre, at 6 dwelling units per acre, which would yield 5 units, 1 of which would be affordable. So those properties are shown in green on this map. The blue properties listed on this map are eligible for environmental analysis, given that they're in common ownership or adjacent to one another, so that's groupings of properties. And then the red sites, which are quite small, are undersized and not available for the analysis, given the small size that they present. We undertook a very detailed site-by-site analysis of those qualifying size properties to identify those constraints on each of those pieces of property. So here we have an example, and this is contained within the vacant land adjustment appendix that's affixed to the plan. So here, this property at Baker Road and Walnut Street, blocks 6001 and lots 132 and 103, we overlaid with flood zones, streams, water bodies, preserved open space areas, wetlands, wetland buffers, and steep slope constraints to determine, the exact developable area of these lots. In this example, as we've shown, we've identified that the property is 100% constrained and not available for development. So despite the fact that if it's listing as vacant, this property would not yield any affordable housing and thus presents a 0 value. So this is just an example of the detailed analysis that we undertook through this process. So it's kind of following up and building on the summary calculation that Mark talked about. Again, first, I just want to touch on the present need obligation. Present need is a statistical census analysis conducted to identify those housing units that exist within the township that are presently occupied by lower moderate income households that are deficient or lacking, that are considered substandard or lacking one of four required components, and these include satisfactory heating systems, plumbing, or if they have an overcrowding condition. This is done at a high-level analysis that the DCA published, and through that analysis, there were no such units identified within the township of Livingston. Should those units have been identified, those are what we call rehabilitation units, or units that are existing lower moderate income occupied that need rehabilitation to ensure that those residents of those properties can maintain their status within the township. However, we have 0 here, so that is not a requirement to address here within the fourth round plan. Second line here in the table is the total prospective need obligation as the township has adopted at 430 units. And then undertaking our adjustment exercise through the vacant land adjustment process, we've identified a realistic development potential on existing vacant lands of 13 units or credits. And then we take that 430 value, subtract 13, and multiply by 25%, and that results in 81 units or credits on properties likely to redevelop. Just want to expand a little bit on the likely to redevelop provision and its inclusion here within the fourth round and all subsequent rounds. The drafters of the legislation foresaw that many communities would have little vacant land available to effectuate development of affordable housing, and as such, they added this provision to require that municipalities undertake an exercise to look at existing improved properties to identify opportunities to redevelop sites to create additional affordable housing opportunities. So that's why we have this provision now within this round and all subsequent rounds to look at those areas likely to redevelop over the next 10-year period.
So even if there's no vacant land, they're asking you to, the state is requiring you to look at property that already has buildings on it and saying you must convert, you must include this in your numbers in reaching the state's required affordable housing obligation.
That's correct, yes. Yeah, just, we've worked in a number of communities throughout this process. I have 2 communities plans that I did where we had an RDP, or realistic development potential, of 0. We had no vacant land in those communities, yet they still had to identify at least 25% of their overall obligation on properties likely to
So you can have a completely built-out town without a stitch of vacant land, and the state still requires you to build affordable units.
I want to make sure that I characterize this correctly, in that the state is not requiring municipalities to do physical construction. The state is requiring that municipalities place land use policy frameworks in place through realistic zoning to allow the private market to develop those sites. Thank you. Hope that answers the question. Okay,
good. Thank you.
So then finally, the last line here within our table presents the adjusted fourth round obligation, which is the sum of the RDP value plus the likely to redevelop value, which is 94 units or credits that the township needs to provide for here in the fourth round plan. Again, just summarizing the obligation compliance strategy, as I mentioned, the present need obligation of 0. However, despite the 0 value, the township still maintains a development fee ordinance and the Affordable Housing Trust Fund, which can support rehabilitation improvements for existing low and moderate income units within the township. And then the prospective need obligation, as we noted, was 430 credits, but yet we have adjusted that now down to 94 units or credits. Okay, so this is really kind of the key crux slide, and I apologize for the smaller font, but we'll kind of talk through it in sequence to discuss the compliance strategy that we've put together here for the township. So the first strategy that has been identified is Cedar Street Commons, property located at 156 East Cedar Street. This is a rental property and has 53 affordable housing units, and this is an age-restricted property. So it's noted that while we have listed 53 affordable units, there's a maximum number of senior units that can be provided through the compliance process. So 5 of these units will be provided towards the required number here within the fourth round. And these units are also available to leverage 2 different bonus types of bonus crediting, either transit-oriented development or also extension of existing affordability controls as well. Next is the property at 45 South Livingston Avenue, where supportive needs and family housing is proposed. We have 34 affordable housing units here provided, and the bonus credit strategy would yield an additional 25.5 bonus credits here, 17 for the supportive needs units, which each get 1 bonus credit, and then the remaining balance are approximate to transit service via bus stops in the immediate area, so that's an additional 8.5 credits. And then finally, we have the Brightview property at 321 South Livingston Avenue, where we have 14 affordable units and 7 total, and 1 capped bonus credit available. And again, we have kind of capping of bonus credits for senior units as well. So you can't have more senior units than you're required to have, and you can't have more senior bonus credits than a certain amount as well. But in sum total of all of these strategies, we have produced 160 total credits, and 79.5 credits are available under the applicable caps and limits. And we also have 93 round 3 surplus credits that have been applied to this approach as well. So in total, and looking at this, we have 172 credits applied, plus the 94, and we have 94 credits required. So in sum total, we actually have a 78.5 credit surplus that's been generated here in round 4 that will be available to carry forward to the future rounds. And I just want to note that, that is based on the fact that we had such a surplus in the 3rd round that we're able to carry that forward and demonstrate full compliance as we move beyond.
Let me also interject.
Yeah, go ahead.
So just to clarify as well, the extent of surplus that we have going into the 5th round, we've identified 74.5 credits that are generated from these projects that create a surplus in round 4. In addition, as noted on around page 25 of your document, we identified various projects from the township's 3rd round settlement agreement that were specified as providing towards the 124 unit surplus that the township availed itself of in this round. However, given these age-restricted caps that Graham was discussing, we did not avail ourselves of all of those bonus credits from the 3rd round, and those will also carry forward into round 5. So just to make sure I'm getting all of my values right, we are applying 93 of the 124 surplus credits. So we are also carrying forward 31 surplus credits from round 3. Yes. So in addition to the 78.5 credits from surplus from this round, the total surplus carried forward into round 5 is 109.5 credits.
And again, that's over and above the 25% that were a realistic redevelopment opportunity.
That's correct,
Right.
yes.
So even after doing that, we still, yeah. Okay.
That's correct. Yeah, and in furtherance to that point, should, as we move beyond adoption and into the challenge period, should any interested party, try and attempt to, introduce a challenge to the compliance plan, given the amount of surplus crediting that the township has, any challenge needs to disqualify those other credits to get it below the 25% threshold to then say, this project or this entity should replace a strategy that we've identified here within the plan. But given the strong compliance and the additional credits that we have, this is a very strong fortified position that the township has to respond to any challenging party.
Is there a net number at this point that we were obligated to based on what you have calculated thus far for round 4 and or round 5 after you apply the credits and assuming they're not challenged?
A net number meaning?
What is our number obligation that
The
we still have?
The minimum compliance obligation, as we've calculated, is the result of the RDP plus the 25%. So the number required to clear is 94, as we demonstrated. Mm-hmm. And then the maps here we've prepared just note the location of the compliance strategies that we've identified. And the purple site is the Cedar Street Commons property, labeled number 1. Number 2 is the Brightview property, and number 3, shown in red, is the 45 South Livingston Avenue site. So what are the next steps? So we have, facilitated this plan through a number of different means, and we want to thank and express appreciation to the township, both the township council and the planning board, for their advisement through this process. This evening here, June 26, 2025, is the planning board hearing and adoption as scheduled. Should the board act favorably this evening on the 4th round housing element and fair share plan, the plan and the adopting resolution shall be filed within 48 hours with the Affordable Housing Dispute Resolution Program and the Department of Community Affairs. That is a statutory requirement. The deadline for that filing is June 30th, and then scheduled on July 17th is the Township Council's endorsement of the adopted Housing Element Fair Share Plan, should the board act favorably this evening, and then the challenge period begins July 1st, as I mentioned previously.
I guess we can clarify that because
Sure.
I think we understood the endorsement had to also be done by June 30th, and we currently have a special council meeting scheduled for Monday, June 30th at
Then
5:30.
that is updated.
For that purpose, okay.
Very
All right.
good. So.
But if we could wait till July 17th.
Thank you,
I'm okay with
Mr.
not
Lewis.
having a special meeting, but, okay.
So, updating my comments I just made, on June 30th, 2025, the Township Council is scheduled to endorse the Housing Element Fair Share Plan, should the Planning Board act favorably this evening and adopt the plan as presented. And that concludes our presentation. Happy to answer any questions or entertain any further discussion.
Can you, if you can you just talk a little bit about the initial numbers that came from the state through to all municipalities, including Livingston, and then what you and the governing body did in response to that?
Sure, certainly. It was back in, I believe it was October of 2024, the Department of Community Affairs, as required under the statute, published a detailed analysis methodology document and corresponding set of numbers presenting a prospective need obligation for all municipalities across the state. Following that introduction and presentation, the DCA also made available all of the back-end supporting data to quantify those numbers, including the Excel spreadsheets, as well as the GIS mapping analysis, which presented the areas that they had identified as developable, consistent with the obligation assignment criteria. I want to make sure that I characterize developable is kind of in two different buckets. So we're talking about how they assign the number of units. The developable land is set forth under a very specific criteria within legislation. It needs to be grassland, agricultural land, forest land. There's a set of criteria that establishes what is developable. And essentially, that developable land is a share of, Livingston's developable land is a share of the region's land, and those communities with more land are assigned a higher value because they have a greater share of developable area. As part of the analysis support that we did on behalf of the township, we went through that DCA GIS output of developable land forensically and identified a series of constraints that existed on those sites, such as deed restrictions or open space or other environmental considerations. And through our analytical work, we reduced that value significantly and identified a revised number that should be adopted by the borough, by the township, given the constraints presented on the developable land that was presented by DCA. As such, then, the governing body effectuated and adopted our revised number based upon the analysis that we had done at the end of January. And there was a challenge period identified by the Affordable Housing Dispute Resolution Program and in concurrence with the law between February 1st and the end of February, interested parties could challenge. The New Jersey Builders Association entered challenges for essentially every municipality that adjusted their number. It was kind of a blanket challenge to all municipalities. The township discussed that challenge and had a settlement session with the Builders Association and a selected judge to adjudicate that process. And a settlement was reached. The township effectuated a settlement at a slightly modified number from the number that was originally adopted by the township.
And, in part of the process working with the state, one of the things that, you hear here and throughout all municipalities is we don't have the room, we don't have the infrastructure, we don't have the school systems, the school facilities to handle, this influx. What's the response from the state?
Sure. So I think what's important is that, through this process, we are guided by the site suitability criteria that's set forth in NJAC 5:93-1.3, I think. Done this a few times, which clearly stipulates 4 prongs of analysis related to each site that we have to identify or review, and that includes the site's availability, whether it's free of title, has a clear title and freely available, whether it's approvable, whether in its condition it is perhaps not zoned at this point, but it presents an approvable location where development can be approved, whether it is suitable, given its proximate location amongst other compatible land uses with access to roads, and then whether it is developable. And developable is where the statutory criteria talks about infrastructure in particular, and its developability is with respect to water and sewer infrastructure only. It does not speak to any other infrastructure requirement to be met in order for the site to be developable. So that is the location of the gap that you're referencing with respect to schools or other public service provisions to support development. The township is required to only look at water and sewer infrastructure specifically in accordance with the statute.
Thank you.
Sure.
When you say water and sewer, that it's the municipality's requirement as part of having to provide the builder to do this is to make sure that you've got the water and sewer for them to do it.
Essentially, yeah, that the selected site has access to the water and sewer to facilitate construct development on that
Well, if the
site.
municipality doesn't have the capacity,
Should the municipality not have capacity in future rounds, there is what's called a durational adjustment for certain municipalities. Other conditions include those municipalities that lack fully provisioned water and sewer service areas, whereby, it needs to be part of an amendment or a forthcoming amendment to the water and sewer service area pursuant to DEP.
but the municipality is not going to be forgiven from the obligation to the number that they've got to do. They've got to go out and figure out how to spend the money to get the water and sewer.
So it depends on the characterization. Some municipalities are leveraging a durational adjustment process, saying that at this time they're not able to, but once they have to make a commitment that once capacity is available, they will ensure that it is allocated to effectuate inclusionary developments or
As
affordable
part
housing.
of the municipality's power and/or as part of development agreements, is it something that, in your opinion, is suitable to be added to development agreements that per unit, there's an additional charge for infrastructure?
I don't necessarily want to opine too much on that. I don't know much about finances of water and sewer infrastructure and what may be necessary. I can just convey to you that redevelopment is an opportunity to discuss financial contributions in those strategies. But with respect to routine charges or maintenance fees, I'm not fully aware of the laws that govern that process. I don't want to opine.
Okay, thank you.
If I may add just an additional note in terms of mechanisms available to the township, all of these applications, or projects rather, will eventually become site plan applications before this body. And as part of that, they are required to submit environmental impact statements, which also must assess impacts on municipal facilities, whether that be schools, traffic, or municipal water and sewer. So that's also a separate time point in the development process where those deficiencies may be identified and corrected as part of the development.
As part of a master plan adopting of what we're talking about here, is there anything that could be implemented to help the municipality cover these costs that are permissible within the confines of what's being sent to us by the state, without that thought process from them?
Sure. So I think that for the purposes of the housing element and fair share plan, we are bound by the statutory criteria of the 4 prongs, which I explained: available, approvable, developable, suitable. We're limited in scope to, site identification or selection based on those 4 parameters. I think it is certainly permissible for the board and the municipality to talk about some of those things as it relates to other, planning exercises or larger scale planning activities and considerations. But as far as the statutory requirement as it relates to the housing element fair share plan, it's pretty much bound by this process that we've discussed this evening.
And the infrastructure impact doesn't, only delays at best.
That's correct.
The construction of these projects. It doesn't do away with the construction of these projects.
That's right.
Okay. Board have any other questions? Seeing none, thanks, Graham and Mark, appreciate it. And at this point, we'll now open the floor to public comment. If you wish to speak, please come up to the microphone and your name and address for the record, and please provide your comments.
Hi, I'm Pretty Maida. I live at 3 Bonnie View Drive in Livingston.
And for the record, can you spell your name, please? Can you spell it?
Okay, Pretty is my first name. Last name is M as in Mary, E as in elephant, H as in hat, T as in Tom, A as in apple.
Thank you.
I'm not very familiar with all of these regulations and stuff like that, so my question for you is, we're seeing the town develop. I keep on hearing about how towns and municipalities have to comply with these affordable housing requirements. I wonder what affordable housing, by the way, looks like in Livingston. But on another note, is there any revenue that the town receives? Like, do these houses pay taxes, or is there any income that, because they're called affordable, are they just like sheltered from taxes, from property taxes and other taxes? Or, yeah, like, I'm just wondering.
This is a good assessment question. Typically, it kind of depends on the characteristics of the project that's being presented and how it's being effectuated. Typically, I can tell you most projects are inclusionary developments, whereby 80% are market rate units and 20% are affordable units. And the property is still assessed on the whole and is, assigned a tax contribution requirement, or the amount of taxes that they are to pay. Typically, obviously, deed restricted affordable units may receive a slightly less valuation than market rate units because of the deed restriction that it must only be occupied by an affordable tenant. So perhaps that slightly reduces it, but given the situation of these projects, typically as inclusionary 80/20, there is still tax revenue that's generated and received by the municipalities.
Do we have any idea of what that looks like right now, or no? Or
On any of the particular projects, or?
this one, like the affordable ones that are, the ones that are.
Well, yes, so as Mr. Petto indicated, some of the affordable units in town already existing and whatever may be, for example, Habitat for Humanity, built for sale, single-family homes, they are deed restricted, and because they're affordable, they cannot be sold for more than a certain amount. So obviously that amount, if it can only be sold for $250,000, we can't assess it for $700,000, so it gets assessed at $250,000, and they pay taxes based on that value. An apartment complex is a little more difficult because you may have, say you have 100 apartments, 80 are market, 20 are affordable. When we assess it, we look at the overall income generated by the project, so 80 of it's going to be generating more higher rents, but the affordable still do generate rents, and those rents and that revenue counts in the overall assessment. So it's really, we couldn't put specific numbers. It'd be on a case-by-case basis of every project, but every unit, with the singular exception, I think, of group homes that, if they're nonprofit, they may be tax exempt. But other than that, they all do. There's property taxes that are generated by it.
Okay, thank you.
Sure.
Thank you.
Thank you.
Anyone else?
Just to add, Barry, maybe you can corroborate this. Some of the properties may even turn into from non-rateable to rateable. So one of them is on the site here is the Brightview, right? So that actually increases the pie for the town.
Correct. As Councilman Batani, Brightview will be built on the existing YMCA site, which was tax exempt. The YMCA moved over to the church, which was tax exempt. So instead of two tax exempts, there will now be, so that's all brand new revenue that will be generated by Brightview, which includes some affordable housing units.
Okay, seeing no further comment, I will now close the public portion. Board members, do you have any questions or comments?
I would just like to, and having been part of this process for, it seems like forever, I'd like to recognize and really thank Mr. Petto and Mr. Linser and Topology as a whole, as well as our Affordable Housing Council, Jared Canner, who's a township attorney. Basically an overall team effort. Jackie's been involved, the board's been involved, the council's been involved. I think it's a credit to the township that we got so far ahead of it, And listen, there's certainly towns out there that, do everything they can to avoid it. And Livingston is not that case. I think there is, as a community, we recognize a need for, the less fortunate people to have places to live. And I think we've stepped up, but at the same time, it's realistic. How many can you put in? How much land do you have? And Topology did an outstanding job. We were initially given a number, I think, of 461 from the state. We came back at 407. We then got the challenge from the Builders Association, actually got a better settlement than most towns to reduce that number. Mr. Petto spoke to the vacant land adjustment because the state kind of just took a satellite map and said, oh, this looks like vacant land, you can build everywhere. And Topology put in the time and effort and went through every single parcel and identified, is it constrained, is it this, is it green acres? And to come up with realistic numbers. And I think it's a real credit that we have been able to meet our RDP plus the 25% likely to redevelop, and then still have I know it was 79, but I think Mark indicated there was some additional bonus credits it's appearing on. Now we're up to 94. So to put that in perspective, that's more than what our 25% was. So it's just a big thank you to Topology for their guidance and expertise, and all the professionals and the mayor and council and the planning board. I think it's a credit to the township.
Thank you.
Okay, seeing no further comments?
Mr. Chairman, just
Oh,
one,
go ahead.
one small ones. So, yeah, absolutely agree. I think great job to Mr. Pero and team and Topology. Look, I mean, this is something that is mandated by the state, and the local governing bodies are required, as we heard it numerous times even in this presentation, to oblige by and sort of comply to these requirements. Each of these units bring in additional housing for our town, and we in the governing body are very, very sensitive about it. I personally can talk about myself. I'm a resident first. 22 years in town, and I've seen my kids go through the school. So some of the concerns are, besides the infrastructure that you mentioned, Mr. Pero, are schools. So one of the things that we do is really share, all of the future projects, and that's how we can govern in town to kind of make sure our facilities are improved accordingly. But at the end of the day, we do have to comply, and that's the part that you articulated well here. So thank you, and thank you to Mr. Lewis as well. He has done a great job, from the township management perspective, to Mr. Cantor, who was our attorney working through with Mr. Pero and the Topology. Working through this process is laborious. It's been several months going in the council, and it has resulted to what the number we saw was 94 as the obligation left for us to do, which is, I think, puts us in a remarkable state compared to, let's say, many of the towns around us or in the state. So with that, I think I just wanted to make sure we have that acknowledgement. And Mr. Chairman, thank you. As you said, it is something that we have to comply by. So thank you.
Rudy, one more, not necessarily a comment, and again, thank you for the hard work that went into it, and I don't know how you stay awake putting these things together, but congratulations. But some assistance too, I mean, basically the planning board is ultimately going to say, oh, it's in keeping with the master plan and we're done. We haven't accomplished anything. Maybe there's some assistance that you could provide in adjusting what we have in the master plan to help. Obviously, the commitment that we have to make, that we're, stuck with, but that to help in the funding of those items, which is kind of what I was asking before, that verbiage in our master plan that maybe gives some ability to the council and the planning board in dealing with these projects as they come up, that there's the opportunity to pass some of these infrastructure costs back along, not just as taxes, but the initial build. And I'm hoping that, I don't know, I can't ask you to do that, but I'm hoping that whoever does, ask you to provide some of that information back to us so that when we're ultimately saying, yes, it's in keeping, that the master plan has things in it that are more beneficial to the municipality with regard to projects that are coming up.
It should be noted too, though, that there's a hookup fee for sewer and water for every unit that gets built, and that's based on capital contributions that are required. So that's all statutory, how you come up with that number, and I'm not 100% sure where Livingston's number is right now, but so when the sewer plant gets upgraded, the future people who come online pay $300 a unit or $700 a unit, and that money is capital to cover the cost of that upgrade.
Okay.
So there is some thought to it in the state process. But if you have to run the sewer line further down the street, that's the kind of thing I think that the developer should be picking up.
Yeah, and to Mr. Diner's point, certainly we are always cognizant, and to some degree, our hands are tied. The municipal land use law has very specific what you can or can't charge for off-track improvements and things. You can only get proportional shares based on their actual addition. We do that. We've done that. We got contributions from Pulte, for example, when they had to run the lines over there, and we do that. And to Mr. Santola's point, yeah, the connection fees, unfortunately, they are significantly higher than $300 a unit. They're like thousands and thousands of dollars a unit. So, so for example, if you had a 100-unit, now, generally, the connection fees on the affordables are either they're lower or waived or paid out of the Affordable Housing Trust Fund.
50% instead.
Right. But then, so say you had 100 market rate units in the sewer that's, I think it's closing in on around $5,000. So there's $500,000 that they would pay in connection fees that would go to help fund those improvements. So there is some opportunities, and we certainly look for and explore and hold every developer accountable for every penny we can get out of them. So,
And thank you, and I understand, sewer connection fee. What I'm just hoping for is that maybe there's some more language that we could throw in that will be more beneficial to you when the time comes to go, here's the bill, dude.
Now, I'm assuming that if any of these require redevelopment plans, they can be part of that process as well.
right, if you do it via redevelopment plan and financial agreements, there's opportunities there to get concessions or contributions over and above and different from just general MLUL. But again, I promise you, we try and get every nickel we can.
Well, to Mr. Diner's point and to the conversation, in the same vein, I feel the 4 prongs that you mentioned, buildability, developability, and all of that, 2 others, I think to Mr. Diner's point, sustainability is missing.
Certainly.
So I think, who decides the 4 prongs, the state or us?
It's in the state administrative code, so it's state.
So talking about verbiage,
Yeah, well.
but thank you for the detailed report. And do we get any pat on the back for being good towns who have complied without contention?
Yeah, that's what you get.
Literally?
You don't get sued.
You stay out of court.
Yeah, I think that's the best outcome.
Anything further? Hearing none, if I can have a motion to adopt the amendment to the master plan as presented?
I'd like to make that motion.
And is there a second? Is there a second? Anybody?
I'll second it.
Thank you. Catherine?
Mr. Chairman, I'd like to also put on the record that Ms. Khan and Mr. Ratner did join the meeting earlier.
Yes.
And was present for the presentation.
Catherine, Khana,
Kana, I'm so sorry, Kana.
Khanna.
Mr. Lewis,
Yes.
Mr. Dufford,
Yes.
Mr. Ratner. Yes. Mr. Diner. Yes. Mr. Buftani,
Yes.
Ms. Wishnu,
Yes.
Ms. Kana,
Yes.
Mr. Santola,
Yes.
Mr. Fernandez.
Yes.
Motion carries. Thank you.
Great. So that's it. Thank you all for participating. Mark, Graham, thank you both very much for the presentation. Thanks, members of the public that came out. Trib,
And thank you,
for
Catherine.
coming out.
Great job covering for Jackie.
Andy in the back, and Catherine, great job, as always. Mr. Diner?
Motion to adjourn.
Thank you.